everyone, today I'll be presenting on the case of Mediacorp News Pte Ltd and iLABS Technologies. So the facts of the case was that the complainant is Mediacorp News, who is a sole provider of teletext services in Singapore, and the respondent was iLABS, who provides various internet services. So what happened was that Teletext.com.sg was registered by iLABS on or about 15 January 1999, and later in April 2001, Mediacorp approached iLABS for transfer of the domain name. However, iLABS requested Mediacorp come up with a business proposal, and after some back and forth between the two entities, the negotiations broke down and Mediacorp filed this complaint.
Paragraph 4A1 of the Singapore Domain Name Dispute Resolution Policy states that the complainant shall be entitled to remedies if the registrant's domain name is identical or confusingly similar to a name, trademark, or service mark in which the complainant has rights. The complainant must first show that he has rights in the name, trademark, or service mark. The complainant would be able to do so if he had a trademark over the name or mark. Thus, Mediacorp would have rights in the teletext name if the name was a trademark registered by Mediacorp. However, Section 26(4) read with Section 15(2) of the Trademarks Act indicates that these rights would only arise after the trademark was registered. Mediacorp did register Teletext as a trademark, but its application to register Teletext as a trademark was still pending as of June 2002. iLABS registered the Teletext.com.sg domain name in 1999. Hence, Mediacorp did not have rights to the Teletext name through their trademark, as they had not registered the trademark at the time when the domain name was registered by iLABS in 1999. Another way in which the complainant can prove that he has rights in the name is through passing off. Mediacorp would have a right to the name Teletext if a Singapore court would prevent other parties from using this mark under an action for passing off. There are three elements to be fulfilled for Mediacorp to succeed in an action for passing off. The first element is that Mediacorp must show goodwill in its business of providing teletext services. This element was fulfilled because Mediacorp was the sole provider of teletext services in Singapore, and these services generated advertising revenue. The second element is that Mediacorp must show that there was misrepresentation or deception by iLABS to lead people to believe that iLABS goods or services were that of Mediacorp's. The panel held that teletext was a generic expression, so there was a need to show that the word had acquired a secondary meaning. However, the panel found that there was no evidence that teletext had acquired a secondary meaning, which was distinctive of Mediacorp's teletext services rather than just a description of teletext services. Also, the panel agreed that there may have been a misconception that such a domain name refers to the teletext services offered by Mediacorp, but this often happens when businesses use the same descriptive word to describe their services. However, the panel highlighted that there was little chance of misconception when the respondent makes it clear that the businesses are not affiliated. iLABS did make it clear that their business was not affiliated by putting a disclaimer on the teletext.com.sg website stating that they were not affiliated to Mediacorp. Thus, Mediacorp would not be able to show that there was misrepresentation or deception by iLABS to lead people to believe that iLABS goods or services were that of Mediacorp's. As the second element was not fulfilled, the panel did not go on to examine the third element in the action for passing off. Also, as Mediacorp did not have the rights in the teletext name, either by trademark or through passing off, the panel did not go on to examine whether or not there had been confusion. Mediacorp's failure to establish that it had rights to the teletext name is sufficient to dispose of its claim. However, the panel went on to make some observations relating to Mediacorp's claim under paragraph 4A2 of the policy. Under paragraph 4A2 of the policy, the complainant is entitled to remedies if the registrant has no rights or legitimate interest in respect of the domain name. There are three main circumstances which could demonstrate that iLABS has legitimate rights or interest in the domain name. Firstly, iLABS would have legitimate rights in the domain name if it has rights under a trademark or service mark on the word that is registered as the domain name. However, iLABS did not register a trademark for the word Teletext and was not known by the name Teletext. Secondly, iLABS would have legitimate interest in the domain name if it is commonly known by that domain name. The internet site with the domain name teletext.com.sg only provided a link to iLABS hosting.com.sg website, so iLABS was not commonly known by the registered domain name. Thirdly, iLABS would have legitimate rights in the domain name if iLABS has used or shown demonstrable preparations to use the domain name for a legitimate purpose. However, the panel found that there was no evidence of this, even though iLABS stated that it wanted to use teletext.com.sg to develop a website. The panel also highlighted that the fact that iLABS was the first to register the domain name and that it carried out due diligence checks before registering does not give it legitimate rights or interest in the domain name. Thus, iLABS did not have legitimate rights or interest in the domain name teletext.com.sg. The panel also considered whether iLABS had registered or used the domain name teletext.com.sg in bad faith. Under paragraph 4A3 of the policy, the complainant is entitled to remedies if the registrant had registered or used the domain name teletext.com.sg in bad faith. The panel found that iLABS had not registered the domain name in bad faith. The panel held that iLABS' failure to develop the website with a contested domain name was not an evidence of registration or use in bad faith. The panel noted that even though the registration had been done quite a while ago and there had not been development of the website since then, there is no requirement for content to be displayed on the website within a certain period of time. Also, the panel highlighted that iLABS' request for a business proposal where Mediacorp would invest in their company portal, which they expected in exchange for their domain name, did not indicate that iLABS had registered or used the domain name teletext.com.sg in bad faith. The panel saw this as a renting of the domain name, which is permitted under paragraph 4B1 of the policy, rather than registering it to sell for a high price, which would be registration in bad faith. Lastly, the panel considered whether Mediacorp had brought the complaint in an attempt at reverse domain name hijacking. However, the panel found that Mediacorp had a legitimate basis in bringing the complaint, but ultimately failed because it could not establish its rights in the teletext name. Thus, Mediacorp had not brought the complaint in bad faith and was not engaging in reverse domain name hijacking. In conclusion, Mediacorp could not establish that it has the requisite rights in the teletext name to entitle it to relief under the policy. Thus, the domain name remained with iLABS and Mediacorp was denied relief under the policy.